Good morning.
Morning.
Mr. Fuller, why don't you come up and have a seat with your. Well, we've got almost everybody we need. Is Mr. Gabriel going to come?
Your Honor, I have not gone out and spoken with him after I sent that email. I was hoping.
I don't wish to do this in chambers. I wish to do it on the record.
Is this the show cause or contempt?
No, it's just that we're not there yet. I just want to make a record of what happened. If I get an appropriate apology, it'll be the end of it. But he needs to be accountable for his actions, and I'd like to speak to him about it.
Speak with him. With that. Your Honor, Mr. Gabriel is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed. I guess I was hoping the court would.
No, I'm not doing it in chambers, and I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm gonna proceed accordingly.
Kendra, we go. Take care.
And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response, but I didn't give him a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in, that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. Well, let's take care of Mr. Fuller and we'll let him get on his way. Good morning, sir.
Good morning, Your Honor.
You got your civics lesson today too.
Yes, sir.
Watching 2 hours of court. All right, this is file number 25760FY. You're Karan Duvar Fuller.
Yes, sir.
You're charged with possession of ammunition by a felon. And that's a new charge. It's a felony punishable by up to 5 years in prison. Your charge is habitual offender. We're going to leave this on for our preliminary examination next Tuesday at 1 o'clock. Do you understand?
Yes, sir.
Now you owe me some money in several cases. You got an old case from 23 of a, what is that? A larceny less than 200. You got some other cases that are already in circuit court, but I'd like you to stop out at the counter about that unpaid stuff. Maybe set up a payment plan to pay it.
Yes, sir, Your Honor.
You're usually, not usually, you're always here when you need to be, and you paid off a bunch of old stuff. I'd like to get that one taken care of as well. All right, you stop out at the counter, find out about what you owe, and I'll see you next Tuesday at 1 o'clock.
Yes, sir, Your Honor.
All right.
You got my number?
No, sir.
All right, don't worry about getting my number.
Yes.
I can give it to you at the court.
That would be May the 20th. 1 p.m.
He just does this. He goes to jail.
All right, we are on the record. And we'll,
Okay.
do you need a minute? Pretty ready. All right, we have 4 preliminary examinations scheduled for this afternoon. Mr. Gary Gabriel is here from the prosecuting attorney's office. Prosecuting attorney Deborah Davis is also present. And the duty attorney for this week is Mr. Ross Truckee. We had these cases for pre-exam last Tuesday and they were set for today. One of the cases, Tegan Jean Landrum, file 25719 FY, has resulted in a waiver and we're trying to track that down. Mr. Landrum was back in the lockup and he'll be taken back out to the jail. Another case that's scheduled for today who is not in custody is Karan Duvar Fuller. Mr. Fuller is charged with possession of ammunition by a prohibited felon. The matter was set for preliminary examination today. Mr. Fuller was here last Tuesday, and we spoke to him. His bond was continued. I made some comment that you always show up when you're supposed to, and now he's not here. Mr. Gabriel has police officers and other witnesses here prepared on that matter. What's your position here?
Your Honor, I've had 2 officers from the Sheriff's Department sitting around here for half an hour now waiting for Mr. Fuller to show. Mr. Fuller is by no means unfamiliar with the process. He was present. He knew he had to be here for a 1 o'clock prelim that he elected. He wanted run. I'm asking for a bench warrant. I'm asking for an immediate bench warrant. I've gone through our records about Mr. Fuller. I've seen the word bench warrant turn up multiple times on cases over his, he's 34 now, so probably about 20-year crime spree. He has 4 open felony cases. One of those felony cases has felony firearm attached. There's conspiracy to steal motor vehicles. And then while out on bond, continually getting out on bond, he's now committed this offense, or allegedly committed this offense. But the proofs are pretty overwhelming since he was patted down and a shotgun shell found on him. I have indicated that if he wants to run the prelim, that's fine. I will be going forward with all of his cases. I have no idea why he's not here. I understand he just lives a couple blocks down. I think that his history, the amount of burden he's putting on law enforcement by continuing while under the microscope of circuit court and this court to just stay out of trouble, he can't do it. So I'm asking for an immediate bench warrant, forfeiture of his, well, it's probably a PR bond, I don't know.
It's a cash or surety bond of $10,000.
Well, I'm asking for a forfeiture of that, Your Honor, and I'm asking that he be held until we can have a bond hearing and I can outline what this young man has cost this community.
I would like to add, there is a warrant request for domestic violence from a few days ago that is pending through him as well. So, wow.
Mr. Truckee, have you had any contact with him since last Tuesday?
No.
As Mr. Gabriel says, this case is pretty straightforward. It's been a very brief prelim. I think the goal was to get the matter bound over to circuit court, package it with all the other 4 cases that are bound over and try to resolve it all. I don't know, maybe it got too overwhelming for him, and apparently there's a domestic violence under investigation, as we just learned. I'm going to do a bench warrant. No 48-hour hold. There is supposed to be a 48-hour hold unless there's good cause shown. Cancel the bond, current bond, seek forfeiture of the $10,000 cash or surety bond. The days of the bonding company going out to look for people has passed. They just wait around till they get picked up, and if they get picked up within a year, they don't forfeit the bond. But once upon a time, they would actually go out and look for them, and I haven't seen it in several years. At any rate, Mr. Fuller, I don't know where you are, why you're not here. if anybody's watching this, he needs to contact his attorney, but there is an immediate bench warrant for his arrest. No bond, and we're gonna seek to forfeit the $10,000. Somebody signed as a surety. If that's forfeited, they're gonna come after you for the balance of it. All right, thank you.
Thank you, Your Honor.
We'll be in recess, and just let me know when you need my assistance. Chambers. You have 4 cases bound over to circuit court. And you were charged with. Mr. Fuller, why don't you come up to the podium? It's file number 25760FY, People versus Karan Duvar Fuller. Mr. Fuller is here without counsel. He just walked in. There's an open warrant for his arrest. This is all a big pain in the neck. He has payment plans in several cases. I think he last made a payment May 19th. May 13th. He has 3 cases bound over to circuit court. No. Whoever's in Karan Fuller, please get out of it. Receiving, concealing stolen property, resisting and obstructing. In file 242019FY. Conspiracy to commit larceny, unlawfully driving an automobile, and larceny of building in file 242020. And then a possession of methamphetamine, carrying concealed weapon, felony firearm, and some other charges in 25454. Then there's this case, which is possession of a shotgun shell or something. So May 13th, defendant's friend called. This was in front of Judge Pattison. Is Mr. Truckee still here? Would you check and see if Ross is still here? Thought he missed court. Then he came in and did a payment plan. And then they told him they had a preliminary examination. It was actually, they had witnesses here on May 20th. He didn't show up. Bench warrant issued, no bond. Expires May 21st.
And that's honest, God, truth, I was not trying to dodge any or run or anything like that.
Well, I knew you weren't, but it's a pain in the neck when you don't show up when you're supposed to.
Yes, sir.
So you called, they told him to call your lawyer.
I did. My lawyer told me to get on my assets or whatever, my things, the line or whatever, and turn myself in.
All right,
So that's what I did, Your Honor.
okay. Well, turning yourself in at the jail and turning yourself in at the court are 2 different things. Your lawyer is, hopefully he's in the building.
Understand.
All right, I don't have any paperwork on this. Mr. Fuller's just here. This is file 25760, so I'll get out of it so you guys can get into it. But I need the paperwork on Karan Duvar Fuller. Hopefully we can find Mr. Truckee. Have a seat, Mr. Fuller. This may take us a minute.
Yes, sir.
He said Ross left the building. I wasn't sure whether he meant you or he was, you were going out for coffee. And no, Mr. Truckee left the building. All right, Mr. Fuller, come back up here. This was set for a preliminary examination where there were, I think they may have even brought witnesses in here. It wasn't the crime of the century, but in light of all the other stuff that you have, the prosecutors sort of getting sick up and fed with this. Mr. Truckee is scheduled to be here next Tuesday morning. So I'm gonna recall the bench warrant, reset PEC. I'm not gonna make them bring witnesses in for Tuesday, June 3rd at 8:30. So we'll try another pre-exam and see what they're gonna do with this. I'm gonna recall the bench warrant. It's more trouble than to put you in jail and book you in and book you out. Although I think the prosecutor I just put you in jail and left you there until we resolved all this stuff. But I didn't think you'd absconded. But it's a pain when you don't show up when you're supposed to. So I've recalled the warrant. I've reset the matter for a pre-exam next Tuesday. Your lawyer will be here at that time. You go to the court officer, they'll take you out and give you a new notice.
Yes, sir.
All right, I'll see you Tuesday morning at 8:30.
See you, sir. Thank you, Your Honor.
Okay. All right, good morning. Mr. Gabriel is here, and we're gonna proceed. This is in the matter of Peoples versus Karan Duvar Fuller.
Your Honor, this is on the record, the light.
Oh, yeah, good, thank you. Thank you, Deborah. Laura came in to check. This is in the matter of People versus Karan Duvar Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabriel and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the Community Corrections Office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee, and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told, so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, on the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor.
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes. But it's MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Gabriel came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with him on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Karan Fuller a PR bond? And I didn't have an instant response, but I didn't give him a PR bond. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabriel was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells I don't have the discretion to cancel his bond because Gary Gabriel is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabriel was to you? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did. And he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect and your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right. And he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock, and we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it. And that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And as I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis.
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to the system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous, with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling?
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Gabriel has the same philosophy that I do as far as holding people accountable and taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as when it's convenient for them. It's not convenient for any of us, and we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what.
Well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Gabriel apologizes for the.
I don't want to hear it from you. I want to hear it from him.
Well, I understand it. We'll give him a chance to speak in just a moment, but from the beginning, it was my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells.
Which
Move
is,
to cancel his bond in circuit court if you could. I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail. And the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week. Somebody shows up. So he's here. You're right. He keeps doing stuff. Or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again. No motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, please don't do this. But it would have been an abuse of my discretion to cancel his bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing. And he's here, and we're gonna drug test him, and you can have a prelim next week.
thank you, Ron.
And this court,
Mr. Gabriel.
first of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who with me taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other. Our wives know each other. We've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream. And you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here, because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing, just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor, who has her hands full, just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And ups, it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail. And I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Karan Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck
He said he's
when this happens. Pardon me?
Yeah, he is a pain in the
Right.
neck.
But he's more than that, Your Honor. He shows disrespect to you too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. But that's the system that's in
Well,
place,
all right,
isn't it?
listen, I agree with everything you said.
And
But
let me finish and then I'll take my admonition. I do not recall that you ever indicated or that I indicated a PR bond. I didn't know what happened. All I knew is you let him, they told me that you let him out. I didn't hear the court rule cited whatsoever. That I think would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just 3 of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years. And I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that. And I feel bad that I did it to somebody that I in the past considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story. Why didn't you do? Ask the defense attorney, what kind of contact did you have? Usually there's the admonition. I'm going to let you out. You're going to be in touch with your attorney. You're going to be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumably a flight risk? Let's not forget that this case, in which he faces life or any term of years because of his past record, is right on the heels of a case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes, we taught a generation of young prosecutors how to be a prosecutor, including our current attorney general. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim if necessary on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond. But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor.
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology and I got one. And the case will move forward and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package, but I'm bound to follow the law. Yes,
You had mentioned the prelim on Friday.
excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday,
Tuesday,
I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me.
I'm sorry, June 17th or the 10th?
Boy, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. I want you to go to the day reporting center right now and we'll do 11 panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
Then it may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Or will you call them and tell them Mr. Fuller's gonna stop there for a 11 panel urine test?
Thank you, Your Honor.
Thank you, Your Honor.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This matter does come on for preliminary hearing in case number 2025 CR 24, State of Kansas versus Lisa Anne Prim. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Ms. Prim appears with counsel Joseph Favre. She's at the Greenwood County Jail.
Is counsel ready to proceed with preliminary hearing?
Judge, we do have an announcement. I've spoken to Ms. Gillette. We're very close to reaching a plea agreement. I've spoken to Ms. Prim. And at this time, we're going to waive our right to an evidentiary hearing and then ask this be set for arraignment, please.
Very well. Ms. Prim, you are charged in count 1 with possession of drug paraphernalia with the intent to manufacture, distribute. This is a level 5 drug felony. You're charged in count 2 with distribution of a controlled substance. This is a level 4 drug felony. You are charged in count 3 with possession of let me make sure I got that right. Count 1 is possession of drug paraphernalia, knowing it will be used to manufacture or distribute a controlled substance, a level 5 drug felony. Count 2 is unlawful distribution of a controlled substance, to wit, methamphetamine in an amount of at least 3.5 grams, but less than 100 grams, a level 4 drug felony. Count 3, unlawful possession of the controlled substance, methamphetamine or MDMA, a level 5 drug felony. In count 4, failure to pay or failure to possess a drug dealer tax stamp on a certain quantity of a controlled substance. This is a level 10 non-person felony. Each of these 4 felonies entitle you to a preliminary hearing. At a preliminary hearing, the state of Kansas has the burden of producing evidence to make it appear that these crimes were committed and to show probable cause that you committed each of these crimes. A preliminary hearing is not a trial to determine if you're guilty or not guilty. It's a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. At a preliminary hearing, you have the right to be present with your attorney, and you have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further detention or for further bail, should you make it. You would have the right to subpoena witnesses, cross-examine the state's witnesses, and present evidence on your own behalf. A preliminary hearing would apprise you about the nature of the crimes charged and the sort of evidence you would be required to meet if you were to stand trial. If you waive or give up your right to a preliminary hearing, there will be no preliminary hearing, and you will be bound over to the district judge for further proceedings. You'll be required to appear at a later date before the district judge for arraignment, at which time you will enter your plea to the charges against you, including the misdemeanors. And until that time, you will be remanded to the custody of the sheriff unless you are able to be released on an appearance bond, and you would continue to be obligated to appear under the terms of that bond. Now, have you talked with your attorney about waiving your right to preliminary hearing?
Yes.
And do you need any more time to visit with your attorney before we proceed?
No.
Do you want to waive your right to a preliminary hearing?
Yes.
Are you voluntarily waiving this right?
Yes.
Has anyone made threats or promises to cause you to waive your preliminary hearing?
No.
Are you in good health today?
Yeah.
Are you taking any medications which might impair your judgment today?
No.
Mr. Favre, do you know of any reason why the court should not accept the defendant's waiver?
I do not, Your Honor.
Thank you. Ms. Gillette, does the state wish to waive its right to preliminary hearing?
The state does, Your Honor.
Very well, the court finds the state of Kansas has waived its right to a preliminary hearing. The court further finds the defendant has made a knowing waiver of his right to preliminary hearing after her right after consultation with counsel. It is therefore the order of the court that the defendant is bound over to the district judge for further proceedings. The defendant shall next appear before the court for arraignment. And Missy, what is available?
This case will go to Judge Ricky, and he is available July 10th at 4 o'clock.
July 10 at 4. Will that work, Mr. Favre?
That's perfect.
Very well. Miss Prim, you are ordered to reappear with your attorney by Zoom before Judge Ricky, July 10th at 4 p.m. Now, these charges allegedly occurred February 25th, 2025. I presume the defendant has been in custody since that time. Mr. Favre?
She has, Judge, and we would like to address that issue of her bond. She's coming up on the 4-month mark here. She's been in custody on this the whole time. She is under a $20,000 cash or surety bond with an ankle monitor requirement. And it's a very onerous bond. I'll just give the court the full picture that she does have a pending hold out of Morris County, and she has already accepted conviction for that offense. That offense was supposed to be presumptive probation. I spoke to her attorney over there, and it's kind of up in the air as to whether that was, I'm sorry, it was supposed to be agreed upon departure. I don't want to misspeak. But I've spoken to her attorney, and I'm not sure how that will shake out now, but he thinks he's still optimistic that it will still end up with her being on probation. We asked the court to consider modifying her bond to something lower she could possibly make, $5,000 cash or surety, keep the ankle monitor if the court is so inclined. She does have a history of FTA, so we understand why that would be something the court would want still. But the truth is that she needs to get a drug and alcohol evaluation for both our case and for Morris County. And it's just very difficult for her to do that process while she's sitting in jail. So that would be our request today.
Does the state wish to be heard, Miss Gillette?
Your Honor, she does have a history of failures to appear. She has had 3 on the case alone over at Morris County, and one of her convictions is failure to appear. She has a history of not coming to court, which is why her bond is what it is. It was lowered to $25,000 at her first hearing in March with GPS. It then was lowered to 20,000 with the EMD GPS in April. Then we had our next hearing today. And so each time we have gone down on the requirement for her bond. With her history of failures to appear, I would ask that the GPS remain on it. Again, we don't know how her case is going to shake down in Morris County. It is presumptive prison. There was to be a departure to supervision. I've looked at the plea agreement in that case, but then she's had failure to appear since then. So I would just ask that the GPS remain as a component of her bond and that it be a cash surety bond. So there's a bondsman knowing where she's at and trying to keep tabs on her as to whether or not she will come to court.
Mr. Fabre, I cannot grant the motion with her history of failures to appear, with her multiple felony counts in more than one county, and with her presumption of imprisonment. I think there's just too great a risk for her to not appear at her next hearing, although I note she is indicating she'd like to speak. Are you wanting to speak to your attorney,
To you,
Mr. Fabre?
to you.
Judge, 1 second. Ms. Prim, I mean, 1 second, sorry. Judge, I don't have an objection to her speaking, but I would ask the court to consider, if the court's not open to a 5,000, maybe something, like 10,000. That's still a fairly hefty amount that a bondsman would go after her on. And if we keep the ankle monitor requirement, that's going to help her, have that extra incentive to not fail to appear. But she's just been in for such a long time, and it's just really hard for her to get a drug and alcohol eval, which the plea we're discussing will likely end up with her in a border box situation. And that, as the court's well aware, that treatment is a very important part to any border box consideration. So that's kind of the basis for what we're looking at. But I guess I'll let Ms. Prim speak for herself.
Ms. Prim, you want to be heard personally?
My thing is, I've only had one absconding. Once have I ever absconded, and that was on this case in Council Grove. I have completed every program, every probation I've ever done. I have never absconded, except that one time.
I think, Ms. Prim, I was going to say, your record on the Morris County case shows there's a couple of failures to appear. Now, I know there's some technical differences between absconding and failure to appear, but I just think it's not a good argument to make that you're not a flight risk, because your record clearly shows you have been a flight risk at least a little bit on this Morris County case.
Once I ran away for 5 years. That was it. I have never had another bond, or another court date or anything. Now I failed to appear because I've been in here the whole time. That's the only reason why I fail to appear. I do when I say I'm going to do, usually.
Usually.
Yeah, usually. But 5 years ago, I was doing drugs. I'm not going to deny it. But I had been clean for 5 years.
On October 17th of 2019, I don't know if you were on drugs or not, but you have a charge of aggravated failure to appear now filed in Morris County. Now they do show, it looks like, that it was dismissed, but it does show that you had that aggravated failure to appear. And you do have the charges that I mentioned in multiple counties. So at this time, I am not going to change the bond. Now, if you want to appear in front of Judge Rickey, he may change his mind and reduce the bond, or not change his mind, but change my position and reduce his bond to you. But I don't want to lower your bond and then have Judge Rickey wonder where you are should you decide you've got too much hanging over your head. it doesn't sound like you've had the presumption of prison over other cases that you have now. So I am going to deny the motion to reduce bond, but I will, if the parties seek it, order that an alcohol and drug evaluation be done in the county jail if someone locally is able to do that. And I know in Butler County that's easily accomplished because of the resources available. I do not recall if we have someone locally that can go into the Greenwood County Jail. Do either of the parties remember, either council recall if there's someone available?
I think we've used Lisa Gray before, but I'm not sure if she's available still.
Who is she with? Is she on her own or does she?
I think it's a new journey or a new direction or something like that. I'd have to go back and look.
Right.
I think we've
Well,
used her.
Well, I will authorize that and I will order that the evaluation be paid for as court costs so that they will have that assurance. Now, that's not telling them they'll be paid right away. But I certainly will authorize that because I recognize she's indigent from being in jail for so long. And if the evaluator isn't willing to accept payment through court costs, then we can revisit that with Judge Ricky and see if we can use other funds. But at this time, those are my orders. Anything else, Ms. Gillette, from the state?
No, I can't think of anything else, Your Honor.
Mr. Favre, anything further from the defense?
Not this time, Your Honor. Thank you.
All right, thank you. Ms. Prim is remanded to the custody of the sheriff. Now, is that Ginger Blades at the jail?
Yes, Your Honor.
All right. Ms. Blades is here on two cases. We're on the record in 24 CR 122 and 25 CR 69. And 25 CR 69, you're accused of violating a protective order. And this is, let's see. This is a Class A person misdemeanor. Penalties include a fine up to $2,500 and a year jail sentence maximum. And this allegedly occurred in Greenwood County, April 17th of 2025. Do you wish to have an attorney in this matter?
I was confused when it was brought to my attention that I had even tried to contact the children because I haven't even reached out to my children in a year. I've only associated with DCF.
All right, but my question is, do you wish to have an attorney to represent you in this case? Jailer's not supposed to be giving you legal advice.
Okay.
You have to make the mind up on your own.
I'm okay. I'm not guilty.
All right, you're going to enter a plea of not guilty. We'll come back to that. You're also here on a warrant to show cause why your probation in the other case should not be revoked. That's the 24 CR 122. The state is alleging that you violated your probation by failing to pay as ordered, failing to report as ordered, failing to abstain from violating the law. In other words, they're saying you violated the law in another jurisdiction. And they're saying that your behavior caused Lyon County, who had agreed to accept your courtesy supervision, to close interest in representing you. So we need to set this for a hearing. You're entitled to challenge these allegations with the assistance of counsel. Missy, when do you want to set this?
July 8th at 3:30 for both cases.
All right, both cases will be set July 8th at 3:30, you said?
Yes.
You must be back here. That's an order in both cases, Miss Blades. July 8th at 3:30. Joseph Favre represented you before. Do you want him to represent you on each of these two cases?
That'd be fine, Your Honor.
All
That'd
right,
be, that's okay. And yes, ma'am.
all right, I will reappoint Mr. Favre in the 24 case and appoint him in the 25. Now I see the bond has been set at 5,000 in the 25 case and a no bond hold until you see the court in the 24 case. I understand you're living in Emporia, is that right?
Yes, ma'am. But I do need to go back to work, so I didn't know if this is a possibility of.
Didn't you fill out a court-appointed attorney form that said you didn't have an assignment right now?
But I have been doing private pay, and it is, I've been assisting. I have a grandfather who is not well at the moment, and I've been helping him clean his house and keep food on the table. And without me, there's no one to take care of him.
Well, we could call social services to check on him and make sure that he's being provided for.
That's just what I've been doing with my spare time since I haven't had my children at home. I've been helping with my.
Okay. Miss Gillette, the court has found this defendant to have a very spotty appearance record in this and another matter. What is the state's position on bond? She's looking at a no bond hold in the show cause and a 5,000 in the new case violation of a probation order.
Yes, because she had a failure to appear at the 25. She had bonded in her, she had a $3,000 cash surety bond on 5/6/25. And then she was given the court date 5/20/25 at 3:30 p.m. and she did not appear on her revocation hearing.
And I might point out that revocation has been pending since March 28th.
She keeps disappearing on us is the problem, Your Honor. If she is bonded, I would recommend it remain a cash surety. So there's a bondsman helping keep track of her. And I've contemplated asking for the GPS EMD on her so that we know where she is at all times.
I'm going to set your bond at $5,000 in each case for a total of $10,000 to bond. And you must have GPS on when you leave and comply with all rules of GPS. Call Mr. Favre as soon as possible. If there's nothing further, we'll be in recess and you're
the next court date,
July 8th at 3:30 on both. And you are remanded to the custody of the sheriff, Miss Blades, at this time. Are you Heather Hunt?
No, I'm Sarah True.
We're on the record in 25 CR 80, State of Kansas versus Sarah Denise True. County Attorney Jill Gillette for the state. Miss True appearing in person, in custody, and pro se. Miss True, you are here on count 1, possession of the illegal substance alprazolam, a Class A non-person misdemeanor. If convicted, your sentence could be up to 1 year in the county jail. Your fine could be up to $2,500. On count 2, you're accused of possession of marijuana, a Class B misdemeanor. If convicted, your sentence could be up to 6 months in a county jail and up to $1,000 in fines. On count 3, you're charged with possession of drug paraphernalia. This is a B misdemeanor also. If convicted, you could be given another 6 months and another $1,000 fine. On count 4, you're charged with no proof of insurance, yet another B misdemeanor. If convicted, you could serve yet another 6 months in the county jail. Your fine would have to be at least $300, but could be as high as $1,000. Do you intend to have an attorney represent you, Miss True?
Yes, ma'am.
And did you turn in an application?
Yes, ma'am. She had me fill one out this morning.
Very well. I have approved court appointment of an attorney. Missy, that's Richard Paul. Is that right? He'll be the one taking the case.
Yes.
You must contact Mr. Paul as soon as possible. And his phone number is 316-303-0100. And when will her court date be?
July 8th at 3:30.
So you must reappear July 8th, 2025 at 3:30. That will be by Zoom, and you must contact your attorney and have him ready to proceed at that time.
Yes, ma'am.
Is her bond set at about 5,000, deputy? By schedule,
Showing 10,000.
10,000. Where do you live, Miss True?
In Morris County, Council Grove,
Who do you live with?
my parents, John and Loretta True.
And do you work?
Yes, I work at Quality Profile Services. It's a plastic and molding extrusion industry.
I may have asked you, are you married or single?
I'm single.
Ms. Gillette, does the state wish to be heard on the issue of bond?
I don't know where I was just looking up her Marion County case that's currently pending. When it's set for.
Is it Marion County or Lyon County, perhaps?
No, it's on her criminal history.
Oh, I do see that. I do see that. She failed to appear on that, it looks like.
Ma'am?
You've got, yes, go ahead.
I'm sorry. Are you talking about me? I failed to appear in Lyon County?
What the state Odyssey program is showing is that in Marion 2023 CR 10, State of Kansas versus Sarah Denise True, you are charged with aggravated endangering a child, putting the child in a reckless situation, possession of opiate, opium, narcotic, or certain stimulant, and also possession of a second substance. All three of these are shown as felony charges dating back to October 18th of 2022, with a failure to appear August 23rd, 23, last activity being August 28th of 23. So yes, that's what we're talking about.
Ma'am, I was on diversion for that. I did my monthly check-ins, and then August of 24 would have been my completion. And I sent in my last check-in, and I never was contacted about a court date. I was never contacted about any such things. I know the cases, I know the charges because I was on diversion for it. There's a lot behind that. And I'm just having a hard time understanding like why it says I missed it.
I don't know. You'll have to check with that jurisdiction to ask them those questions. At this time, Ms. True, I'm going to leave your bond at $10,000 cash or surety, EMD required before you can be released. And you're to contact your attorney. Be back here by Zoom July 8th, 2025 at 3:30. If there's nothing further, you are remanded to the custody of the sheriff at this time.
Thank you, ma'am.
You're welcome. Your name, please?
Molly Wood.
We are on the record in 2025 TR 50, State of Kansas versus Molly Nicole Wood, County Attorney Jill Gillette for the state, Defendant Molly Wood in person, in custody and pro se. Miss Wood, you failed to appear 3 times for first appearance, so this your 4th time. We will actually go over rights and charges. In count 1, you're charged with driving while your license was suspended, a Class B misdemeanor. If convicted, the penalties could be up to 6 months and $1,000 in fine. In count 2, you're charged with violating the ignition interlock requirement following a DUI. That charge is a Class A misdemeanor. If convicted, you could serve up to a year in the county jail and pay a $2,500 fine. You do have the right to an attorney. I see you did apply for an attorney, and I have looked at your application. I am appointing Attorney Richard Paw to represent you. You must call Mr. Paw as soon as possible at 316-303-0100. You will need to reappear with him by Zoom, and Missy, that date will be?
July 18th at 10 o'clock.
You must be back here by Zoom, July 18th, 2025 at 10 o'clock. You must contact Mr. Paul as soon as possible and talk to him in order to be ready for that court date. Because of the three failures to appear, I'm contemplating continuing a no bond hold. But Ms. Gillette, do you wish to be heard on that?
Judge, $5,000 didn't get her back here. I have no idea how much it's going to take to keep her coming to court since she keeps disappearing on us.
Judge,
Yes.
not this one, but the last one. I was in the hospital and I emailed you guys everything. They thought I was having a stroke. And the court that I missed, and when I was picked up May 2nd, my court April 25th, I was in the hospital in the ER by 10:30 that morning. I had court called, I had emailed paperwork, all of that, of my appointments and what had happened, and called for a week after trying to get another court date.
That was the court date before the last one.
Well, this last one, I thought I had 30 days. I thought it was a 30-day continuance from May 2nd.
Where do you live?
Huh? El Dorado.
How long have you lived in El Dorado?
All my life. Well, besides Benton and, huh?
Did you go to school there?
I went to Roselia and El Dorado.
Who do you live with now?
Myself and my kids. And a camper out at the lake.
A camper at the lake. And what kind of work, if any, do you do?
I'm disabled.
Do you get a disability check each month?
Yep.
Do you live at the lake in the camper year round?
There's another situation happening, and it was a have to kind of pack a bag type thing to get out of the situation. And we've been there, have been there 2 months. I'm waiting on income-based housing for a house to open up is all I'm doing.
How many children do you have?
2.
You get any kind of child support for them?
It's ordered. I have not gotten any from my youngest dad since last October, and have not received anything in, I think, 2 months from my oldest dad.
Well, I'm frankly concerned that you've had 3 failures to appear. You're living in a camper at the lake for the last 2 months. You apparently don't have a permanent residence. You don't have a job. Did you tell me you do or do not get a disability payment?
I do. And the reason I'm in a camper is because there was a PFA filed. Like, that was the kind of situation on why I had to get out.
All right. How long have you been getting disability payments?
I've been disabled. My son, my youngest, is 10 since he was 2, so about 8 years.
And do you always let the Social Security Administration know where you are, where they can get your checks to you?
Yeah, it's direct deposit into my account.
All right. Ms. Gillette, what have you to say about bond in this case? I mean, I've asked you before, but do you have anything now that she's answered?
Judge, she has a long history. There's lots of issues with her traffic record. And I am aware there is a recent PFA filed because they let me know that her ex-spouse has, or to-be ex-spouse has custody of her child. And there is lots of verification as to why she does not have a driver's license, and we have downloaded the extensive amount of notifications to her. I don't know if it's because she moves around so much. We have 3 failures to appear. 1, she did send emails. The other, she did not.
Because again, that was on me. Sorry.
Please don't interrupt.
Sorry.
We'll take turns.
I have notes that she was interrupting, acting the same way on 4/8/25. I would request that if the court grants her a bond, that it is $7,500 cash or professional surety. I don't know that we shouldn't put EMD on her because she keeps disappearing. Seems like we have a lot of those today that like to disappear. It's not always the case, but today it is.
Mhm. How many cases does she have pending, if any others?
I didn't look that part up. I just looked at her driving history.
Miss Wood, you look surprised and in disagreement when she said your ex-spouse has the children or the child.
Yeah, which ex-spouse has custody?
Well, when you went in, you had custody of the child? You only have one?
No, I've got 2. My oldest one, they're, again, problem with the butler, but my youngest one I have sole custody of.
All right, so
which
there's
is
one.
my ex.
All right. When you went into custody, what provisions did you make for the children?
He was supposed to go with my friend Marla, but then we decided to let him go with his dad. So that's where he's at right now.
Now, are you secure at the lake for now, or when are you going to get out of the lake?
All I'm doing, I've already filled out my applications. Maylee helped me too with Greenwood County. I've done the website for Greenwood County and Sedgwick County and Butler County and put my name and all of that and filled out the application and put my name in so that when an sector, what do you call it, income-based housing opens up, they'll let me know. I did get approved for one in El Dorado on 6th Street, those new houses, but they told me that my rent was going to be $975 and I can't do that. I mean,
I'm setting your bond at $7,500 with electronic monitoring device required. And you make sure that your bondsman and your attorney know where you are and how to reach you at all times.
Okay.
And you're going to be back here July 18th, 10 a.m. with Mr. Paw. And if you fail to appear on me one more time, I think you're going to just have to sit in jail until your hearing.
Okay.
Maybe after your hearing. All right, we'll be in recess. You're remanded to the custody of the sheriff.
So that's something I get.
There's Heather Hutt, right?
Yes, that's correct.
Okay. We are on the record in 2025 CR 79, State of Kansas versus Heather Dawn Hunt. County Attorney Jill Gillette for the state. The defendant, Ms. Hunt, appears in person, in custody, and pro se. Ms. Hunt, in count 1, you are charged with aggravated intimidation of a witness or victim by threat of force or violence. And this is filed as a level 6 person felony. A level 6 person felony carries possible sentencing ranging from 17 months to 46 months in the Kansas Department of Corrections, known as prison, with a fine up to a possible $100,000. In count 2, you're charged with violation of a protection order as a condition of pretrial orders. That is filed as a Class A misdemeanor, a Class A person misdemeanor, If convicted, your sentence could be up to 12 months in the county jail where you are now, and also a fine up to $2,500. Miss Hunt, do you wish to have an attorney?
Yes, I would, please.
If you turn in an application for an attorney?
No, I just got here. They picked me up at my
Okay.
house.
Have your financial circumstances changed since Mr.
Yeah, I'm
Paul?
only working one job now because of some health issues.
All right.
And I don't even know if I have that because I was supposed to be at work and they came and picked me up and I didn't have time to call them.
All right, well, let's have you fill out an application. The jailer can help you get that.
Thank you.
And I will probably appoint Attorney Richard Paul if he'll take the felony to go along with your misdemeanor.
Okay.
I believe is pending jury trial, if I recall.
He is. Yes, that's correct.
Missy, when do you want their first appearance to be on, or their status hearing on this?
Let's set it June 20th at 1:30.
All right, we'll set this for what we call preliminary hearing control, June 20th at 1:30.
Okay.
You call Mr. Paul as soon as possible and let him know what's happening here.
I will.
And we will go from there. If Missy can't get him to take that case, then she'll find someone else and you'll have two attorneys. But I also expect you to turn in the application, even though I'm granting Mr. Paul or granting an attorney. So at this time, you're on a no bond hold.
I was gonna see, ma'am, if there was any way I could do an OR bond because I really can't afford to lose my job and my house. I have a dog at home. I've showed up to every single court hearing. I haven't missed any. I've done everything that you've asked of me. I think I've proven that. I've lived at the same residence for 3 years. I'm not going anywhere. And I did not have any contact, and I can prove that.
Well, that's what I was going to say. According to the state, you haven't done everything I told you to. I told you to stay away from certain people, and they claim you had contact, but that's to be determined at a later date. Ms. Gillette, does the state wish to be heard on bond?
Your Honor, I want a strict no contact order with the person that is protected AE. The contact happened right before the jury trial was to be held for pre-trial conference on the Monday. It happened over the weekend area time frame. And so I'd ask for strict no contact GPS so we know that she is not around that person and where she's at, not to be at the school, period. Not even if it's a public event near the child. No being near the home or anywhere else that they may be.
Ms. Hunt, I'm going to set your bond at $5,000 cash or surety required with the conditions that you have absolutely no contact with the 4 children or their father, that you wear a GPS at all times through EMD, that you contact your attorney as soon as we confirm that Mr. Paul will take your case. So check back with Missy later this week. And I believe that takes care of everything. Is there anything else from the state, Ms. Gillette?
Nothing else on this matter, Your Honor.
Ms. Hunt, anything else?
No, ma'am. Thank you.
You're welcome. You're excused and remanded to the custody of the sheriff at this time.
I'll be right back with the other two, Judge.
Thank you. Chad Irvin, are you here? I'm looking for Chad Irvin. We are on the record in 25 TR 179, State of Kansas versus Chad A. Irvin. County Attorney Jill Gillette for the state. Mr. Irvin appears in person and pro se. Mr. Irvin, you are here on one count of driving with an expired tag or other problem with your registration. This is an unclassified misdemeanor. It has penalties of up to $2,500 in fines and 30 days to 6 months in jail, but that's pretty extreme and more than we normally see. Let me look at your. Okay, I was looking at your prior record. It looks like you've got a number of things on there that would probably keep you from diversion. I can't say that's not my program, it's Miss Gillette's. You can always apply if you want, but are you going to have an attorney represent you in this? I can't hear you, sir. You're gonna have to get right in front of the microphone.
No, ma'am.
What are you wanting to do with this? Are you wanting to plead not guilty and set it for trial? Plead guilty, admit it, and proceed to sentencing? Plead no contest, not admitting or denying, but proceed with sentencing? How are you wanting to proceed?
Well, it was just a problem with my driver's license. I moved to Oklahoma and I hadn't gotten my driver's license changed.
Well, let me double check because I thought it was a tag violation.
The tag is, I just renewed the tags in April.
This says vehicle, improper registration of vehicle as of April 29th, 2025. This was a citation written 5/1/25 by Trooper Wagner, who alleges that on April 29th, 2025 at 11:19 in the morning, you were driving on US Highway 400 inside of Butler County.
Greenwood.
Greenwood, I'm sorry, with an improper registration of your vehicle. So that's what you're accused of. You do have the right to plead not guilty and set this for trial. You have the right to an attorney. You can hire any attorney of your choice because there is the possibility of a 6-month sentence, even though I've never seen it imposed. You can apply for court appointed. So do you want to hire an attorney, apply for court appointed, or waive an attorney and represent yourself?
Yes, just represent myself.
All right. Well, do you understand for the record that you do have the right to hire or apply for court appointed?
Yeah, I mean, I guess I don't know.
I'm not trying to talk you into anything. I just want to make sure that if you waive, you understand that you do have the right to an attorney and you can hire or apply. Do you understand that?
Yes.
And knowing that, do you want an attorney or do you want to waive attorney and represent yourself?
I would like a court appointed attorney, I guess.
Are you employed?
Yes.
How much do you make per month?
Probably more than, I don't know. I've never.
Well, why don't you fill out an application before you leave today? You can get one from the security office there. And I will set this over. Missy, when's the next court date?
I guess we'll set it July 18th at 10 o'clock in case he gets an attorney.
July 18th, 10 o'clock. You must be back here. You must turn in your application today and then call Missy later in the week to find out if you qualify and who your attorney will be if you do. I don't believe you've been put on bond at this point. So I'm going to order that you go over to the sheriff's office and sign a 500 OR bond. You know, this is a Class C misdemeanor. I am not required I'm not gonna make you go over and post a bond, but don't fail to come to court or I'll probably issue a warrant. So you don't have to go over and get the picture and prints taken. Just make sure you comply with filling out your court-appointed attorney and calling Missy later in the week. And don't miss court July 18th at 10 a.m.
Can I ask a question, ma'am?
Sure.
Is this just a fine, or I really don't know what's going on here. I have legal tags and I just moved to Oklahoma, but I still had a Kansas driver's license when he stopped me.
Ms. Gillette, are you reading that the way it looks in the Odyssey system, that it is not a improper driving without license?
It is 8-142 subsection 6, not registering your vehicle where you reside. He admitted that he resided at Cessna, that his home address is in Kansas, and that he is registering his vehicle in Oklahoma. And so you have subsection 6 says you must register where you reside, your vehicle.
So, oh, I'm sorry. So if you're applying for an attorney, the attorney can explain and decide if you have a defense or not. But that's what you're charged with.
Okay,
Which is,
this is going to court either way, going to trial either way.
I'm not setting it for trial yet. I'm setting it for a status control for you to have time to talk to the attorney if one is appointed, or to give you time to hire one if you want.
Okay.
And did you say 7/18?
Yes, 7/18 at 10 a.m., sir.
7/18. Okay.
Maybe you can have someone write that down if you don't have a pencil. Always bring a pencil to court. Always, always, always. All right, if there's nothing further, sir, you are excused at this time with the condition that you reappear July 18th at 10 a.m.
Thank you.
You're welcome. Who is the gentleman at the jail?
Gavin Vickery.
Let's take your case up. We're on the record in 25 CR 11, State of Kansas versus Gavin Lane Vickery. County Attorney Jill Gillette for the state. The defendant appears in person, in custody, and pro se. Mr. Vickery, you were originally charged and had your charges reduced from a felony to a misdemeanor. You were put on probation, and now the probation officer is alleging that you have violated your probation. So we need to set this for hearing. You did apply for court-appointed counsel. Looks like I had some questions about that. You yourself are employed at Sickcut, is that right, in Neodesha?
It's Sicut. Yes,
Sickcut. And Textron in Wichita?
that was previous.
Okay. You're now making $2,000 a month, is that right?
Yes, Your Honor.
Your spouse is a stay-at-home mother, is that right, with no income?
Yes,
You have $2,000 that you've been saving to buy a new car, is that right?
yes, Your Honor.
And you own a home worth $100,000?
Yes, Your Honor.
Well, that $2,000 could be used to hire an attorney.
Yeah, I really need a vehicle at the moment. My car now has 190,000 miles on it, and it shuts off like a lot. It's just in bad condition, and I really need a new vehicle, but I can, yes.
That's the Chevy Cruze worth $700 that you mentioned.
Yes, ma'am. I mean, that's what I would value it at.
Well, I'm going to go ahead and appoint an attorney to represent you.
Okay, thank you, Your Honor.
but you better use that money to get the vehicle. Because you
I
do
will.
need transportation to get back and forth to work and such. All right, let's see, when's his hearing?
July 8th at 3:30.
You must appear in person at the courthouse here in Greenwood County, July 8th at 3:30. I'm going to reappoint Attorney William McClendon. You better get a hold of him right away. Will he be here, Missy, around July 8th? Do you remember what time frame he's going to be gone?
He's gone in June.
June. All right. So contact Mr. McClendon in the next few days before he just goes on another matter, and then be back here with him July 8th at 3:30 on a warrant to show cause. Check in with your probation officer as soon as you're released. What do we have him on bond, deputy?
Currently, no bond.
No bond. Miss Gillette, any recommendations?
Judge, Mr. Vickery was sentenced in February. He had his BIP evaluation in April. Started BIP after that. We've had some reports come over from his BIP attendance. He's already missed one of his classes. He and the victim have basically been openly violating the no contact order from the moment he was placed on probation, maybe before. There's been a lot of back and forth. It's gotten to the point where his mom has harassed his CSO to the point they're only dealing with the chief CSO over here. He's missed a meeting with her and just openly living against the no contact order. The allegations are that, and today is not the trial for the revocation, but his significant other, who he has the no contact order with, I'll say allegedly for now, jumped out of a moving car at 70 miles an hour when they were in an argument. But then she says she's not afraid of him. So it's either one or the other. She ended up in ICU and he ended up at the ICU, and I had to send the journal entry with the no contact order over to Labette County.
Now, is this alleged to have occurred while he's on probation?
Yes, and the no contact order has not been lifted. They just keep wanting it lifted, even though there's still been lots of issues between them. And
Let me stop you there. Missy, is this the same person that sent me an email, if you know, telling me that she wants contact with her husband, that he's a good
Yes.
guy? He's a good guy and she's not afraid of him. Okay, go ahead, Miss Gillette. I'm sorry. I just wanted to make sure
they've
was
been
thinking.
openly violating the order from the get-go. And he's, like I said, it's been a mess. And I don't know that even if we put EMD on him, that she won't come to him instead of him going to her. But it resulted in another incident over at Labette County, and I don't believe the two of them should be together until he has fully completed a BIP course. And I don't know how to get that through to them. But we can't keep having all these incidences where they end up injured.
I'm going to apply a $50,000. That's 50,000, 50,000, 50,000 cash or surety bond with electronic monitoring and no contact with this victim. Also, make sure they're not having contact through the jail by telephone calls. Missy, can we expedite that hearing? That July 8th, can you fit that in somewhere else?
Well, I'll have to see if when Mr. McClendon can be here.
Good point. All right. For now, your hearing is July 8th at 3:30. William McClendon is your attorney. Electronic monitoring, $50,000. Cash or surety, no contact. Nothing further. Will be in recess, and you're remanded to the custody of the sheriff, Mr. Vickery.
I will find out
Yes,
if
we-
he's going to be here.
And we'll need to make sure his probation officer can be here too. Thank you. All right, now I'm looking for Van Howerton. Is that you?
Yes, ma'am.
We are on the record in 2023 TR 108, State of Kansas versus Van Orman Howton. County Attorney Jill Gillette for the state, the defendant, Mr. Howerton, in person, in custody, and pro se. Let's see, Mr. Howerton, you were sentenced to June 9th of 2023. Pay or appear was set. I believe you had that continued, but then you failed to appear thereafter. You haven't posted your $453 bond. Are you able to do that?
Today, you mean?
Today, I mean.
I don't think I can, no.
Okay.
I didn't even realize I had a court date I was supposed to be at. I had an attorney in Wichita, but I went to on video court to a court date. Last time I spoke with the judge.
Well, I would have given you the date myself of when to reappear. Now, he may have gotten the new date and passed that on to you.
Well, I had recently become homeless, so I don't
You're
know if they
homeless?
couldn't. So I
You're
recently,
homeless?
yeah, and I don't think that the attorney I had when I was there probably couldn't reach me or something. I don't know, but I didn't know anything about a court date.
Well, I show him as pro se, Missy. Did he have an attorney?
Not here.
Yeah, I don't believe so. Wait, he did have Shannon Cooper back.
Yeah, that was originally, yes.
Yeah, when he pled, he had Shannon Cooper. And this was a pay or appear date that he failed to appear for.
And so Miss Cooper would have been excused and you would have been told to just come back for pay or appear to see if you paid or you didn't.
Right,
Miss
yeah,
Gillette,
I've been unemployed.
Miss Gillette, what would you say about this case going to collections and not using further efforts?
When did he get arrested, Your Honor?
It was recently. Deputy, can you tell me when he was arrested on this?
You got arrested. Oh, it was Tuesday. You got arrested last night?
Last night.
And the warrant was issued in 23, wasn't it?
Yes, and then Sedgwick County contacted us and we went and picked him up this morning.
Okay, so they've been dealing with him. Are they through with him or do you know?
Yes, as far as I know, they had no charges on him.
Okay. It's been in collections for a while. They've attempted garnishment.
Yeah, I haven't had any employment yet. I do have a disability case pending. In fact, I have appointments to go see their doctors next week, as a matter of fact.
Okay.
Judge, I'll give him credit towards the sentence. Ask the court to modify the sentence to time served. We'll put it in the journal entry.
Modify sentence to time served. Deputy, you don't happen to know what that is right off, do you?
I do not.
Can you let Miss Gillette maybe know and she can put that in the journal entry?
Yes.
Okay. Time served, and then the case can continue through collections. And when we get that information, Deputy, I'm going to close the case and let collections deal with it. It looks like they're aggressively going after him.
Okay.
All right. So if there's nothing further, we'll be in recess. The defendant is remanded to the custody of the sheriff until all the paperwork is completed.
Thank you.
Thank you.
You're welcome. Thank you.